My name is Bruce Elman. I'm a professor of law at the University of Windsor. I teach constitutional law, and I have taught criminal law and evidence in the past. My research interests are in the area of freedom of religion and freedom of expression, and I've focused a lot of my career on the Charter of Rights. When the Charter comes into effect in April of 1982, I'm still a visiting scholar at Stanford. I get back July 1st, or thereabouts, 1982, and all of a sudden I start getting phone calls from average citizens saying, such and such has happened, I have rights, don't I? Now, in many of these instances, it had nothing whatsoever to do with rights. And in fact, a case that I actually consulted on, the individual in there whose lawyers hired me to consult with them thought that he had a charter argument, but it turned out he had actually an argument based upon traditional federalism grounds. But it was this kind of atmosphere where people believed that they had achieved some major milestone in securing rights that they did not have previously. And therefore you would get these kind of random calls from individuals, members of the public, who were claiming that the government had done something, or sometimes not even the government, but that something had happened to them that was a violation of their rights. And that was probably one of the more interesting parts of the post-April 1982 scene, at least for me personally. The other thing that was interesting about that time period is there was the most massive education program for judges and lawyers that I think the country has ever gone through. It was just simply astounding, the number of speaking engagements that one was invited to talk about various sections of the Charter. And some of those speaking engagements actually led to published works in learned journals, and some ended up in more accessible professional journals, or some ended up even in the public domain, or more public domain. But there was this kind of focus on the idea of producing serious educational programs for members of the court and for members of the legal profession. And that went on for at least a couple of years after the Charter came into force, and then had a rebirth in 1985 when the equality rights provision came into force. And so we went through a period of time, and I don't know how many years we'd be talking about here, but certainly from 82 through at least 87, where there was this kind of heightened degree of professional education for lawyers and judges. That was quite astounding, really. I think they can, but I think the educational program for lawyers and judges was a bit more, I don't want to say technical. Technical is maybe not the right word I'm looking for, but it was much more focused. I think that members of the public need to have a better understanding of what it means to have a constitutionally entrenched Charter of Rights, and that it has certain implications for democratic societies. And I'm not sure, even to this day, we've gotten that through to members of the public in the way that we really need to do. I do a presentation quite often to high school students in which I talk about the 10 most important concepts you need to know to function in society. And one of those concepts is the idea that the Charter is an anti-majoritarian document. That is, that it's about securing the rights of those individuals who are not part of the majority. And you can look at that in terms of free speech, or freedom of religion, or association, or assembly, or any of the fundamental rights, but also in terms of all of the rights of accused persons accused of criminal offenses. So I'm not sure that we yet have inculcated the culture that everybody understands that there are limits to government action, and that this document is there to, in fact, promote a type of democracy that is not simply majoritarian rule, that it has other elements to it, and that is the securing of rights for people who are not part of the majority on any particular issue.